Hear ye, hear ye, hear ye. The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business. Draw nigh, all ye having business with this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. Good morning to everyone. We will begin this morning with introductions from the court. I am Mike Hevican, and I am the Chief Justice. And now, by order of seniority, the other members of the court will introduce themselves.
Good morning. I'm Lindsay Miller-Lerman.
William Castle, good morning.
I'm Stephanie Stacy. Good morning.
Good morning. I am Jeff Funk.
Jonathan Papik, good morning.
And John Freidenberg.
Thank you, members of the court. Our bailiff this morning is Allie Stewart.
Good morning.
And with that, we will proceed to the first case or cases of the day. That would be State Ex Rel Brooks versus Evnen, which has been combined for oral argument with State Ex Rel La Greca versus Evnen. Ms. Gras, good morning to you.
Good morning, Your Honor.
Yes, and before you approach, Mr. Heffron, good morning to you also. And is it Mr. Gayshak? Oh, I'm sorry, Mr. Rodney. I jumped down way too far. Good morning to you. And is it Ms. Hayes? Good morning to you. Do any of you have any questions before we begin? Then I have a question. Ms. Graz, you appear to be going to take 9 minutes. Is that correct?
That is the plan, Your Honor, yes.
And Mr. Heffron, you are scheduled to take 6 minutes. And you understand you've got to calculate that yourselves.
Yes, Your Honor.
Very good. Ms. Graz, you may proceed.
Thank you, Mr. Chief Justice. And may it please the court, my name is Brenna Graz on behalf of the relator, Dr. Catherine Brooks. The reserved power of initiative is an important power. Its importance requires the people to steward it well. Sponsors must carefully, cautiously, and clearly draft the text of a proposed constitutional amendment to avoid constitutional violations. Because once petitions begin circulating, the language is set in stone. Once proposals make their way into the Constitution, the only opportunity for revision is another constitutional amendment.
Counsel, if the language is set in stone once the petition starts to circulate, why can't a single subject challenge be brought sooner?
Your Honor, according to this court's precedent, we, via justiciability, this is a procedural requirement that seems to have indicated that we need to wait for the secretary to review the language, certify whether the language is going to go on the ballot, and depending on that decision of the secretary, that's when the challenge comes to direct the secretary to do or not do something.
Has there been a single subject determination by the Secretary of State in this case?
The Secretary of State has certified the initiative for the ballot. And presumably, because that has happened, he has gone through the procedural requirements to say, have the signatures been validated? Does this comply with single subject rules? Is this a resubmission clause issue? And the court has construed all of those things as procedural requirements that are required before the secretary certifies something for the ballot. One of the things that Ms. Brooks, the relator in this case, did was send letters to the secretary. And then a case was filed and the secretary said, I'm not going to decide anything based on your concerns for single subject, because we attempted to raise those concerns to the secretary. He said, I'm not going to address that.
In the related La Greca case, right?
Yes.
Did relator in that case correspond to the secretary, ask for a reaction?
I do not have, I'm not sure that there's anything in the record in that case making that determination, but I don't know if that actually happened in that situation. But again, I don't think that there's any statute or rule that requires parties to reach out to the secretary, do a, what I would call a letter writing campaign in order to ask the secretary to do something.
Does the secretary have a statutory duty to make a determination?
The secretary has a statutory duty to make a certification, and within that certification duty comes seeing if the petition is procedurally proper. And this court has said that the single subject provision is a procedural requirement, and the
It's a
procedural requirements are
it's a
something.
pre-election justiciable.
Right,
Right,
yes,
okay.
yes.
So what did the secretary say about the single subject? Good, bad, no reaction?
The secretary said, I'm not going to get involved in this, even though we attempted to raise that to him, and said, I'm going to let the court make the final decision. So it's my understanding that because he certified this petition for the ballot, it's presumed that he said this checks the box for single subject purposes.
So he implicitly approved it.
That's correct, Your Honor. That's how I would understand it, because
Gets
this
over
court
that
is
statutory duty. Now it's before us.
correct. Yes, because it's considered a procedural requirement. Your Honors, I will begin by briefly addressing the question of a general subject, and then I'll move to 2 reasons why I believe this initiative fails, regardless of how this court adopts the general subject. I'll discuss how the initiative creates multiple competing rights, and I'll discuss the redefinition of a medical practice in standard. It's revealing that no party in this case agrees on what the general subject of the initiative is. The relator and interveners propose very different general subjects. The interveners proposed subject to limit government interference with abortion, for example, ignores the creation of affirmative new state constitutional rights. This court in Wagner is an example of adopting or including in the general subject the recognition that new state constitutional rights are being created while treating regulation as a separate subject. In our brief, we explain some of the difficulty about identifying one unifying purpose in this language. But in our brief, we offer, for the sake of argument, a general subject of creating a constitutional right for women to obtain abortions before fetal viability. And this would track the structure of Wagner's general subject. It would also recognize the new constitutional right that's being created. It tracks the initiative's language, and it reflects how the U.S. Supreme Court has characterized the previously recognized right to abortion. But regardless of whether this court adopts relators' assumed general subject or the interveners, or decides that there is simply no unifying purpose, this initiative fails for multiple reasons, and I'll touch on 2. First, the creation of competing rights. The initiative states in part that all persons shall have a fundamental right to abortion. It says all persons. It does not say all pregnant persons or all pregnant patients or all women. The first clause is not limited to a personal right. And neither does the right to abortion have limiting language attached to it. It does not say to obtain or to seek or to have, nor does it say a right to personal autonomy or reproductive freedom, some things that we might see in other states. It just says to abortion. This language goes beyond merely personal rights of a woman. The plain, most natural reading of the text is that it includes all persons, mothers, fathers, parents, personal rights, and third-party rights. Interpreting the intent of the sponsor's language is limited to the words of the initiative itself. Different language means different things, as the U.S. Supreme Court has recognized. All persons.
Is this a single subject argument, or is it a confusion argument?
Your Honor, it can be both. I think the fact that this language is confusing is evidence of a single subject violation. It is not a separate requirement, but it can be evidence that something has gone wrong here. And we're looking specifically at the plain language of the text. We're not talking about hidden motives or hidden ideas like what the interveners raise in their brief. We're not talking about Indian law or tribal lands like we were in McNally. We're looking at the text of the language, and the plain meaning of the text says all persons. We can't read something.
Has anyone has anyone anywhere ever created a third-party right to abortion?
So that's the problem with this language is most states don't have something like this. The only thing that I'm aware of is one state that uses relatively similar language, but they have different single subject jurisprudence and they already have something similar in statute. So I am not aware of this actually. I think that shows the problem here with the confusion of the language, because this is something that hasn't been done before. And it shows the distinction between the two rights that could potentially be created. Now, whether this court after the election construes the language in a certain way is a substantive question. At this juncture, at a procedural stage, we have to look at the face of the language and the plain meaning of the words. That's not something, we can't read words into the statute or out of the statute at this point, because We are not allowed to look into the motives of the reason why the sponsors drafted such broad language. We have to look at the face of the language itself. For example, Your Honors, the term pregnant patient and patient are used separately for separate purposes. Pregnant patient is only used to identify the person who the life or health exception measurements apply to. And the term patient is only used to identify the practitioner who is assigned constitutional authority to determine the extent of constitutional rights. Reading the text otherwise would both read words out of the text, making persons mean something else, like limiting it to pregnancy status or biological sex, and reading words into the text, like reading limiting words in: obtain an abortion, have an abortion, seek an abortion. Your Honor, it's the sponsors who selected this broad language. It is not the fault of this court or the secretary that they did. These competing rights are analogous to the two distinct rights that are created in Wagner. In Wagner, the initiative created personal use rights and separate property rights regarding medical cannabis. And here, the two competing rights on the face of the initiative lack any connection, let alone a natural one, like the case in Wagner. And before my time is up, I want to briefly touch on the second issue, is the creation of new medical standards and practices within the redefinition of viability. The interveners argue that this is simply something that is showing the limits to, or is defining the when of a right. But this redefinition goes far beyond that. It not only transforms the right itself to an unidentifiable degree, but it also delegates, for constitutional purposes, the authority of a healthcare practitioner, not a physician, to be the determiner of when rights end. The language says until fetal viability, and then it says viability means when a practitioner makes a certain determination. So this is now shifting the burden onto a healthcare practitioner to define when constitutional rights end. This is not something that is necessary for the creation of the rights themselves. And Your Honor, out of respect for Mr. Heffron's time, I will yield the remainder to him.
Thank you very much. Mr. Heffron, good morning again.
Good morning. I'm Matt Heffron, and I represent relator Carolyn LaGreca, who is in the front row of the courtroom today. The Protect Right to Abortion initiative establishes 1, late-term abortion for nearly any meaning; 2, abortion without any limitations or restrictions; and 3, presided over by non-physicians. This is a sea change in the current Nebraska law, which was popularly enacted by representatives. And each one of these should be voted on by the voters separately. The drafters of this initiative had the choice to have different initiatives, just as was instructed and approved in McNally, but they chose not to do so.
What do you make of the argument that virtually every bill that has gone through the legislature on this topic has all of these same subjects, pieces?
Sure. They're two entirely different standards. One, the legislative single subject rule is based on a situation where the terms are actually hashed out by the various members in the legislature. It's very public, and by the time you get the terms voted on, everyone knows exactly what they mean. In the initiative process, entirely different. A different constitutional provision as well, established in 1998 because the legislature determined that they needed to enforce that. It needed to enforce that on the initiative side as well. In the initiative context, there simply isn't the time for everyone to hash out the terms and to know the terms. And in fact, the likelihood is that most voters are going to come into the voting box having never seen this, or certainly not as constitutional lawyers and know all the various provisions that will go into place. Now, it's easy to see that this case is a textbook case of log rolling. And it's pretty obvious and easy to see by 3 examples that come out of our brief. First, the health exception allows for abortion throughout pregnancy. How do you know that? Because with the terms, you have to select meeting. And the meeting, I can't imagine a better place to go than the U.S. Supreme Court. With all difference to you folks as well. But the Supreme Court established in Doe v. Bolton that health means almost anything. Emotional health, familial health, general health. And if you want to look for another place for a definition, the World Health Organization adds as well social well-being, whatever that may be. General well-being is another one that Doe v. Bolton adds. And so for that reason,
Council, what provision of this proposal do you contend that someone who is opposed to abortion, generally speaking, would be in favor of adopting? What portion?
the way that we defined the general subject is what I think many voters, at least I think that's the bet of the sponsors, that many voters will vote for abortion up to viability, maybe a majority. But those same voters will not necessarily vote for late-term abortion. In fact, almost certainly will not. As noted in the Brooks brief, the Gallup poll shows that across the country, up to 72% of voters reject late-term abortion. And yet the voters in this case here in Nebraska, they'll have the choice of abortion up to viability, but they'll have to only pick it if they're also willing to go with late-term abortion, which most voters across the country do not. And as showed here in Nebraska, we've had some of the groundbreaking laws like the Pain Capable Abortion Act, the Partial Birth Abortion Act, to stop that late-term abortion, and those were popularly enacted. Another place that I'm sure voters are not likely to go or not be willing to vote for, and that is without any sort of regulation. The terms in this initiative, without interference from the state, have been defined before. In fact, they had to pluck those right out of the Casey decision, because Casey said, if you just use without interference from the state, it's not the same as fundamental rights. Fundamental rights always have regulation. That was Casey, and that's, as we know from the standard time, place, and manner restrictions on First Amendment rights, there is always some regulation of fundamental rights. But Casey stated that if you use the words without interference from the state, that is something different than fundamental rights. So this initiative, in the same initiative, causes two different standards to be used. How is a voter supposed to determine that? How would a voter know that? They might want to vote for viability abortion, but they're not going to say with no other regulation by the state.
Without interference from the state or its political subdivisions, is that a form of log rolling?
Yes, exactly, Your Honor. That's what I would say is an example of log rolling, a very definite example. And the last one is that the healthcare practitioners in this case have been defined in only one place that I know in Nebraska law, and that's as under the Credentialing Act, which you just dealt with or just issued an opinion on last week. And in that act, that healthcare practitioners are defined so broadly, it would include easily pharmacists, psychologists, all shades of nurses. And actually, if you read that Credentialing Act, it would also include athletic trainers and masseuses. But that's how broad it is. And that's what this initiative did. They didn't have to elect such broad language. They chose to. And because of that, they give no choice to the voters. And that's the log rolling principle. And quite honestly, I would argue very little choice to you. You're the constitutional arbiters here, and they violated the Constitution. And I see I've well run beyond my time. Thank you very much.
Thank you very much. Mr. Rodney, good morning again.
Good morning again, Your Honors. May it please the court. I'm Paul Rodney. I'm appearing on behalf of the interveners in this matter, who are the sponsors of the Protect the Right to Abortion initiative. The initiative has a single subject: limiting government interference with abortion. Each component of the initiative's two short sentences naturally and necessarily relate to that general subject. That is why the Secretary of State approved the initiative and certified it for the general election ballot. And that's why this court should affirm that decision and let the voters decide. Now, the relators have gone to great length to tease out multiple subjects in the language of the initiative. But rather than multiple subjects, these arguments point to substantive objections that are outside the single subject analysis. We agree with the relators that the court has made clear review should focus on the actual text of the initiative. And as this court described in McNally, to the extent the proposed initiative might have repercussions that are not apparent from the text of the initiative, whether such repercussions are unintended consequences or ulterior motives. It is an argument that should be made to the voters rather than to the secretary or to a court performing a judicial legal sufficiency review. Relators' challenges squarely tee up that issue. Their objections to the initiative's substance should be communicated to the voters, and the voters should get to decide whether the initiative becomes part of the Nebraska Constitution.
Does that, those kinds of questions brought up, does that make the, and assuming this would be adopted by the voters, does it still have some legal vulnerability after that point in time because of the language that was used?
Yes, Your Honor. I mean, a new constitutional provision can be challenged after it is adopted into the Constitution, just as other provisions have been challenged over the years. And it will be likely this court's responsibility down the line in the specific facts of a given case when it comes up to determine if provisions of the initiative are incompatible with the rest of the Constitution.
So those challenges are not pre-election justiciable. Is that right?
That is
in your
exactly
view?
right, Your Honor. Our view is that all the challenges in the petitions are not justiciable because they are pre-election challenges contingent not only on adopting the initiative into law, but potential scenarios that could but may not evolve in the future. And if we look at the language in the relators' briefs, you'll see much conditional language. There are many ifs and possibilities posed. None of those are facts before the courts. Those are unright. That is an unright determination at this time. All that matters now is whether the components of the initiative all have singleness of purpose and naturally necessarily relate to the general subject of the initiative.
Does the initiative allow the state a role in regulating abortion?
Well, again, Your Honor, I think that is for the court to determine in the future because it relates to a post-election implementation. But at a general level, yes, I think it does allow the state a role in regulation.
What would that be?
Well, the relators brought up Casey. I think Roe is the more appropriate case to look to. Under Roe, the U.S. Supreme Court established that a pregnant patient has a right to abortion in the first trimester without interference from the government. But under Roe, many states implemented regulations that pertain to medical care and abortion care specifically. And in Planned Parenthood v. Danforth, the U.S. Supreme Court 3 years after Roe struck down several portions of a Missouri law, but affirmed portions of that law that regulated the practice of abortion, including informed consent, including record keeping, and other areas. So if we look to history as a guide, the fact that a patient has a right to an abortion without interference from the government doesn't mean there is zero role for the government.
You're just making a distinction between interference and regulation.
Yes, Your Honor.
So
Not
the
every
exact
regulation.
language without interference from the state still allows for regulation?
It would still allow regulation, Your Honor. It wouldn't allow regulations that interfere with the right, and the court will have to determine what the boundary is. I don't think today we know what the boundary is. We don't have the facts that help us get to that point. But that is part of the potential repercussions that the
Is this a
initiative has.
judicial admission that can be used later on?
I'm not sure. I mean, I think it's consistent with the court's jurisprudence. This is anything we say today on the record isn't going to be part of a future record. But I think we're comfortable accepting the fact that without interference doesn't mean completely free of all regulation, as long as the regulation doesn't interfere.
Does the initiative create a right to abortion to third parties?
No, Your Honor, we do not think that is a natural reading of the language. We certainly don't think it's the most natural reading of the language. We think the natural way that the voters will understand this language is that the right attaches to the person who is pregnant.
Well, why do we not use the term pregnant patient versus all person?
You're right, Your Honor. It certainly could have done that. It did not. And we don't think that creates a third party right. We think the language read naturally refers to a patient who has.
This sort of
pregnant.
begs the question, where did this language come from? Is this modeled after some other state or some model language that we can turn to look, for example, as to whether or not this is a single subject?
This language, as far as we know, it's not identical to other states' language. It is, you'll see overlap with other states. The ballot before the state of Florida is one related set of language that hasn't been adopted yet because it's up in the current general election. Michigan in 2022 adopted a language that uses the same concepts and some of the same exact language, not all of it, but substantially overlaps with this language. So those two states come to mind, Your Honor.
But the Florida case was limited to can this go on the ballot?
The Florida case was a single subject. Yeah, yes, Your Honor. It
Single
was
subject challenge and the pre-election challenge. Can that initiative go on the ballot and survive a single subject challenge? And it was determined that it could. Is that correct?
That is correct, Your Honor.
Thank
It was the same posture as we have before us today.
What we're talking about with the language, healthcare practitioners, is that an expansion of the current law? Are we talking about masseuse and athletic trainers? Are we talking about physicians or who does that include?
We do not believe it includes masseuses and athletic trainers, Your Honor. It is an expansion, right? Under current Nebraska law, only a physician can be involved in the process. This
Does
is
it include dentists?
We do not think it includes dentists, Your Honor. We believe, as has been implemented in other states, it would be healthcare practitioners who have the skill and expertise to be a
Does it
care provider.
include midwives?
It could include midwives, Your Honor. And I think this is again
Certified midwives or lay midwives?
Well, Your Honor, I think that is another future repercussion that this court might have to grapple with. We assume, and it's our expectation, that the court will draw some boundary at some point, probably, but it would be the expectation that it would be a healthcare provider who has the expertise to provide care to a pregnant patient. We don't think a dentist, under current professional ethics, under existing obligations, would seek to become the treating physician for a pregnant patient for the pregnancy.
Could the legislature later define healthcare practitioners?
I think that would probably be a close call, Your Honor, and this court would have to grapple with that. The language of the initiative certainly leaves it open to allow a pregnant patient choice of who to provide prenatal care.
You've told us what you believe would the people who put it together thought, but what would we base that upon now? If that was challenged immediately upon application, what would we base that upon?
Well, there will still be prevailing codes of professional conduct, Your Honor, medical ethics, professional codes of conduct. And there are other systems in place to restrict providers from going outside their lanes, if you will. So we still I would expect that those boundaries still exist.
Does this initiative give an unfettered right to minors to have abortions?
It gives a right to all pregnant patients, Your Honor. It does not distinguish based on age.
All people.
All people, exactly. That was consistent with the holding of Roe, quite frankly. It was the same. That was the same situation in Roe.
Would there be any applications as all people have a right to abortion, that a parent could direct their child to have an abortion even if the child did not?
No, Your Honor, I don't believe that would be compelled by the initiative. The right is for the pregnant patient, not a parent. So I mean, based on the plain text of the initiative, which is all we have before us, a parent could not compel a minor to have a baby or not have a baby. It would be up to the pregnant patient.
Does that question even come before us for the issue that we have before us today, though?
It does not, Your Honor. This is, again, one of the repercussions, the potential repercussions of the initiative, and would be a post-election issue.
How would you define the general subject of the initiative?
We define the subject as limiting government interference with abortion, Your Honor.
Where do you suggest we look for the general subject?
We have to look at the actual text of the initiative, Your Honor. So we look at the two sentences of the initiative.
Does the object statement have any impact on our decision?
The object statement can be, absolutely, the court can consider the object statement. I think you'll find that the object statement is largely consistent with the language of the initiative.
So
Does
the
the-
petition, beg your pardon.
That's all right. Go ahead.
The petition sponsor sworn statement indicates that the petition is protect the right to abortion - constitutional initiative. Does that inform us as to what the subject is?
That I think the court can take that into account. And usually that is not part of the full determination because that's not the way the Secretary of State certified the initiative for the ballot, but it's certainly in the record and can be, I think the court can consider it.
What do you think are the current status of the law interpreting what single subject means is in Nebraska?
Well, Your Honor, the law as established in the most recent case in Christensen, McNally, and Wagner, the law is that, I can quote from Christensen, frankly, the controlling consideration in determining singleness of subject is the initiative's singleness of purpose and relationship of the details to the general subject, not the strict necessity of any given detail to carry out the general subject.
So you're focused on initiatives pertaining to constitutional amendment proposals. That's the square you're in.
Yes, absolutely. Absolutely, Your Honor. And here, to address a point.
As opposed to what other squares?
Well, this court's considered the standard for municipal election initiative measures, and also statutory measures brought forth by the voter, by citizen petition, or by the legislature.
So the variables are statute or constitutional amendment, initiative versus the legislature. Those are the combinations.
Yes,
How
Your
about
Honor.
the city council?
I'm sorry, Your Honor.
Is that an option too, the city council?
I guess I don't think I
I
understand.
think earlier you made reference to the
Municipal.
Yeah.
Right. I mean,
That's
it would
the
apply.
Drummond world.
Yes, it
Okay.
would apply. It would be like the Lutheran standard would consider the municipal standard. Before us today, though, as Your Honor points out, we're in the constitutional checkbox, and the standard is fairly well defined based on the most recent elections, like the cases from the last two elections.
How early can a single subject challenge like this one be raised?
Your Honor, we agree with the relator's discussion. Until the secretary, under the current process, until the secretary confirms that it's been certified for the election, we don't believe the challenge can be brought. So that led to the compressed timeframe we're obviously all under today. We had to short Secretary of State Edmund announced his certification about 2 weeks ago, and that escalated our
So is
process to
that
get
all
here.
based on the sort of rightness concept?
That is exactly, Your Honor. It's based on rightness. If the initiative is not certified for the election, then this court would be issuing an advisory opinion.
So could this court change our concept of rightness in regard to initiative petitions?
I don't. That is an issue I have not considered before today, Your Honor. I don't know that the court can do that under the current structure. It might require a statutory change for that to happen. It would certainly facilitate the process because, as we know, we're under an accelerated timeline to deal with weighty issues.
It would seem that the box we're all in now is not a very good box.
I agree, Your Honor.
And most of the things we've talked about today on both sides of the fence in regard to what is the definition of health providers and so forth, put the legal system in even a worse box. Do they not?
I think that's right. I think this was perhaps an undesirably quick process. But to be sure, within the confines of the structure we have, the only issue is whether there's a single subject at this time. Pre-election, is there a single subject? We believe there is. We believe it is limiting government interference with abortion, and that is why the court should affirm the Secretary of State's decision to certify for the election. I seem about out of time. If there's no further questions, I will sit down. Thank you, Your Honor.
Thank you very much. Do we have any time for rebuttal?
No, Your Honor.
Counsel, there is no time for rebuttal. That concludes arguments in the combined cases of State Ex Rel Brooks versus Evnen and State Ex Rel LaGreca versus Evnen. Hence, you are excused, and the court will go on to the next case of the day, which is State Ex Rel Constance et al. Versus Evnen.
Linda?
You may, but don't start anything yet. We've got folks coming in and out
Won't
of
say a
the
word, Your Honor.
courtroom. Thank you. And you must be the anticipated Mr. Gayshock, is that correct?
Yes, I hope I come close to living up to the anticipation, but I
Well.
doubt I will.
And I apologize if I mispronounced that.
It's excellent pronunciation, Your Honor. I think it's, which is not the usual experience I have.
I had some hints early on. So, good morning to you, and Mr. Campbell, good morning to you.
Good morning, Your Honor.
You're going to be the only person arguing for the relator, is that correct?
That is correct, Your Honor.
And Mr. Campbell, are you the only person arguing for the respondent?
That's correct, Your Honor.
Very good. With that, Mr. Gayshock, you may proceed.
Thank you, Your Honor. With the court's permission, I'd like to reserve 2 minutes for rebuttal. Good morning, Your Honors, Mr. Chief Justice. My name is David Gayshock. As I said, I'm here with Joshua Livingston and Teresa Babendreyer, and we have the honor to be before you this morning representing 29 Nebraska voters who are current or former physicians treating patients here in Nebraska. And we're basically here for one reason, Your Honor, in this unfortunate box, as you put it, Mr. Chief Justice, before, of timing, which is to provide a vehicle for the court to apply the single subject test equally to both ballot initiatives that touch on the subject of abortion. Dr. Constance and her fellow relators would not have challenged what we're calling the restrictions amendment for ease of reference, the Protect Women and Children Amendment, were it not for the challenges filed by the relators in the prior case. But since those challenges were filed, Dr. Constance and her co-relators felt it was important for the court to have before it both initiatives so it could apply the standards equally to both. Our bottom line, and what we would urge the court to do, is to affirm and leave undisturbed Secretary Evans' decision to certify both questions for the ballot. We think the rights amendment clearly qualifies under the single subject test. We think the restrictions amendment probably does as well under this court's jurisprudence. However, if the court were to apply a more tightly focused, stricter approach to the single subject test as urged by the relators in the prior case, we think that the restrictions amendment clearly would fail that test far before the rights amendment would. And that's why we're here today.
For example.
So for example, 2 examples, Your Honor. I think one would be, as we heard in the prior argument in the briefs in the Brooks and LaGreca cases, the rights amendment is challenged on grounds that it, by using all people, encompasses arguably, in the relator's view in that case, men, women, minors, etc. And also that it contains, it's also challenged in the briefing in that case as addressing multiple situations of exception like medical emergency versus viability. Taking that same standard and transporting it over to the restrictions amendment, we have at least 6 subjects. Again, we don't think this is the best standard, but if you apply the 2 equally, we would have restrictions on abortion or bans in both the 2nd trimester and the 3rd trimester. We would have exceptions created, potentially, arguably rights created for in 3 different situations: sexual assault, incest, and medical emergency. So under the approach urged by the Brooks and LaGreca case relators, those would all be separate subjects. So that's one. Again, we don't think that's the right standard. Taking a step back.
If it were the right standard, that would mean, for example, that it would have to be a petition initiative and people would have to vote on incest, they'd have to vote on rape.
Exactly. One by one, piecemeal, either on the same ballot or on subsequent ballots. Yes, we don't think that's how this court has articulated the single subject test. We think that would frustrate the rights of the voters to pass constitutional amendments as reflected in the Constitution. There's a second bucket to answer your question as well, Your Honor, that is, just as the relators in the Brooks and LaGreca petition have raised concerns about the potential spillover effects of the rights amendment in terms of which medical practitioners are able to take certain steps, or whether viability is being redefined for purposes of state law. The same thing would apply, and even more so, on the restrictions amendment by the seemingly intentional choice to use the framing of unborn children being protected from abortion. There was a much more direct way to say, had the drafters of the amendment chosen to, abortion shall not occur, or abortion shall be prohibited in the second or third trimesters. But instead, the language is framed in terms of unborn children, phrase not currently used in the Nebraska Constitution. There's no recognition in the Constitution, as your honors are, I'm sure, aware of any recognition of personhood before birth in the Constitution right now. But the intentional choice, seemingly, to use unborn children and make it a passive phrase as opposed to an active one, opens up the same sort of Pandora's box of potential impacts across other areas of law that the relators in the Brooks and LaGreca cases claim would happen in the rights amendment case. Again, we don't think that's the right test. I think that you heard from Mr. Rodney a better argument than I could make as to why that's the case. But if that's the test that the court chooses to apply, it obviously needs to apply the same test to both initiatives, and that's where we would be. I'm going to briefly address the question of justiciability, because I know that the interveners in our case raised it and we had not specifically briefed it. I don't think there's a justiciability issue here more broadly than the overall questions of this sped up process, as your honors were pointing out in the prior argument, that are inherent in this setting. There is an actual case or controversy here, to the extent that it's a dispute over whether the restrictions amendment passes the single subject test. The only contingent event here is not a fact that still has to happen or be determined. It's not an agency decision that still has to be made. It is only how the court chooses to frame and apply the single subject test in this particular setting here in 2024 on this subject.
So is this what you're saying, so that in Brooks and LaGreca, if the initiative were permitted to go on the ballot, then the initiative here should also go on the ballot?
Yes, I would say that we could make an argument, and I think a good faith and credible one, that the petition, the initiative in this case, is closer to the line. But bottom line, we agree with the way your honor just framed it, that the voters should just be able to decide on the two amendments, the two initiatives, rather than having one be on and one be off. They should rise or fall together.
Thank you.
Do we have to decide LaGreca and Brooks first before we get to your case?
I'm not sure that the court has to do that. I obviously defer to the court can make its own determination as to that, but I think that makes the most logical sense for the following reason, and that is that if the LaGreca and Brooks decision is to apply a broader focused view of the single subject test,
We have to put that in an opinion. We decided these cases first.
I think it could even be in a combined opinion for both, or it could be cross-referenced back. I think if that's the case, I think the decision in the Constance challenge could be as short as a paragraph or even a sentence that says, because there is, of the way we decided and the way we applied the single subject test in the Brooks and LaGreca cases, relators in this case have conceded that if that amendment, if the initiative and the rights amendment makes the ballot, that the restrictions amendment challenge is no longer being pressed, that the court could deem that to be a voluntarily dismissed argument. It could dismiss it on other procedural grounds short of having to substantively pass on the two, or it could engage in a combined analysis of both amendments if the court so chose in its opinion, and apply the same standard to both of them. I think there are multiple ways of approaching that. But the key bottom line point is filing this petition was the only way to ensure the court had the procedural ability to have both amendments before it, and therefore to apply the same construction of the single subject test equally to both. So that's why we're here. I would like to point the court very briefly to, in terms of the ripeness analysis, almost all of the cases.
Let me ask you
Yes, Mr. Chief Justice.
what I asked earlier. Could this court change its ripeness tests?
The ripeness test is a mix of a jurisdictional test and a prudential test, but it is, to my knowledge, judicially created. And I think this court could, given that it's particularly that it's a context dependent and fact dependent test, and this court has repeatedly noted the fact that it's a matter of degree and it turns on the facts of each specific case. I think this court could decide that ripeness, particularly in the context of ballot questions where this very compressed timeline exists, would be judged by a more specific or a different standard than in other cases potentially. And obviously that would help to solve, as you noted, Mr. Chief Justice, the horrible time box that everybody is operating in with Secretary Evnen having to finalize the ballot by the end of this week. So that I think the court is free to do that.
Should we revisit our previous conclusion that single subject is a procedural matter, first for the Secretary of State to determine as part of the legal sufficiency analysis, and one that is justiciable pre-election?
I don't think we have a particular view on that, Justice Stacey. I think the provision in the Constitution, Article 3, Section 2, does obviously specify in a very short declarative sentence shall contain only a single subject.
Is that procedural or substantive?
I mean, I think it's the court's found it to be procedural. I think it's procedural. It seems to be something that does make good sense to a judge before the voters are asked to pass on a particular question rather than only afterward.
When do we address single subject when a legislature enacts a statute?
Typically afterward, but I suppose, I mean, a bill, I'm just thinking of examples recently. I'm not sure it's required to be afterward, although you might have a ripeness issue on that front, at least raised. But in both cases, there's more play in the schedule also for the legislature potentially too, in terms of when bills are introduced versus when they're enacted, that the court may be able to fashion a more court-friendly and user-friendly timing doctrine out of. Here, because of the fact that there is an election that has to happen on a particular date, and by a combination of federal and state law, Secretary Evnen has to certify that ballot so far in advance. I mean, the court's put into a very difficult spot, as are the parties, of having to compress these challenges into a short time.
What is the certification deadline this year for the Secretary of State?
I believe the final ballot language deadline this year, my understanding, is this Friday, Your Honor. So
So do we have to decide this case by this Friday?
to affect the language that goes on the ballot, yes. I believe there is a secondary option of the court could order the secretary and the state elections officials working under the secretary to not count and not certify results for a question that did appear on the ballot. But that's obviously a fraught with voter confusion issues as well, because you'd have a ballot printed that contained a question that then the question would be whether that would be counted or not. That seems like another suboptimal outcome to say the least. So that being the case, I do want to point the court to one particular example. And again, back to the point about the only contingent issue here on the justiciability front being the court's application of the test. It's very similar to actually the cases that my friend on the other side cited with respect to ripeness in terms of City of Omaha versus City of Elkhorn, and the case it cited, City of Millard versus City of Omaha from 40 years earlier, in which I think that a unanimous court in 2008 in City of Omaha versus City of Elkhorn explained that there wasn't a ripeness issue because the issue had become ripe as soon as the court made a determination on a particular appeal as to annexation that then made the rest of the issues that were before the court ripe at that point. be the same analogy here. So unless the court has any further questions now, I'll reserve the rest of my time for rebuttal. But thank you all.
Thank you very much.
Thank you.
Mr. Campbell, good morning again.
Good morning, Your Honor. Mr. Chief Justice, may it please the court, James Campbell on behalf of the interveners. This action is unlike any legal sufficiency case this court has ever seen, and that's because the relators in paragraph 30 of their petition concede that the Children Initiative meets the constitutional requirements for inclusion on the ballot and that Nebraska voters are entitled to consider it in November. That concession sinks their case for two reasons. First, it shows that there's no right case or controversy, and so this court lacks jurisdiction. And second, their claim fails on the merits because in order to get mandamus relief, they must show a clear right to relief, and that concession shows that no clear right exists here.
Does the concession pertain to a matter of fact or a matter of law?
Your Honor, it pertains to a matter of law, but I think a concession as to a matter of law is also binding on a party. So I would start with the jurisdictional point, unpack it a little bit more. Again, there's no jurisdiction here because there's no right case or controversy since the party who instigated this action agrees with what the secretary did.
What did the secretary do?
The secretary issued a letter, and the letter said that the Protect Women and Children's Initiative is certified for the ballot.
Is that procedural? Is it single subject? Is it all of those things?
I think it's a procedural determination, and that gives rise to the potential to raise a single subject challenge under this court's jurisprudence.
So you agree with your opponent or those who have argued that it's an implicit determination that there is but one subject?
I do think it is an implicit determination of that.
All right.
Is there time between now and September 13th for the Secretary of State to change his mind?
I suppose he could, but I don't see any signs that he's going to. So I think at this point, because of that implicit determination, it's incumbent on this court to resolve this dispute to the extent the court thinks that there is jurisdiction. And again, our frontline argument is that there's not.
So do we have to wait and decide this till the 13th?
No, I don't believe so, because
If
again,
he has the ability to change his mind between now and then, what impact does our decision have if we're released today or tomorrow or Thursday?
Your Honor, I think his decision, his ability to change his mind is something that is inherent in any case. Any party can change their mind at any point in an appeal and move the case. So I don't think it should deter the court from ruling based on the implicit determination.
You're sort of importing the idea that before judgment, a trial court could change its mind.
I don't think it's, well, Your Honor, I wouldn't analogize the secretary's determination to a trial court's determination. I would analogize it to a government official making a decision that is now subject to a lawsuit. The government official
He
can
can change his
reconsider.
implicit decision.
Again, I think he could, but there's no sign that he's doing that here. So I think it's, to the extent the court thinks there's jurisdiction, I think it's incumbent on the
Right.
court to go forward. The key point I want to make, the only remaining point I want to make on jurisdiction, is that one of the points that my friend on the other side made this morning is that there is no other way to do this. And I respectfully disagree with that. There are many other ways that this could have been done, this sort of challenge, that would have likely preserved this court's jurisdiction. First, the relators could have simply and directly argued that the Children's Initiative violates single subject principles. They didn't do that. Second, they could have brought another relator into the case that would have made that challenge. They didn't do that. And third, they could have intervened in the existing Brooks and LaGreca matters because they claim that their entire case is contingent on the outcome of that case. Well, that's the natural thing to do when you have a claim that is contingent on the outcome of an existing lawsuit, is you intervene in that lawsuit. And there's precedent for folks to intervene in this court's pre-election procedural determinations. That happened in the McNally case.
What right would they have asserted in the other case where their position seems to be that that initiative should go on the ballot?
They would have brought some kind of a cross claim against the secretary, and they would have said, to the extent that the court agrees with this challenge to the abortion initiative, then the court has to correspondingly issue a ruling directing the secretary to withdraw the children initiative from the ballot as well.
And how is that conceptually distinct and different from what they've done here?
It's conceptually distinct, Your Honor, because there is jurisdiction in that case. There is not jurisdiction in this one. So to intervene in a case where jurisdiction already exists and to bring a contingent claim makes perfect sense. To file a standalone lawsuit with a contingent claim that depends on the outcome of a different case, there is no jurisdiction. Moving to the merits.
What if we were to decide LaGreca and Brooks first? Is the contingency met then?
I think there's still a problem in that. So there's two ways, obviously, the court could decide that. You could decide to reject the challenges in those cases, which would allow the abortion initiative to go on the ballot. And if that's the case, I heard my friend this morning say that they have conceded that their challenge goes away. Now, if the court rules the other direction and finds that the abortion initiative should not go on the ballot, I still think they have a problem in that in paragraph 30 of their petition, they conceded that the children initiative meets the requirements. You can't come to court, concede that what the respondent did was legally correct, and then claim there's a right case or controversy. So I still think they have a problem. As to the merits, the single subject rule is satisfied here because every aspect of the one sentence children initiative falls within its general subject and primary purpose.
Which is?
That primary purpose is to create constitutional protection for unborn children from abortion that closely mirrors existing Nebraska statutes. Starting with the second clause of the provision, that's the independent clause that said unborn children shall be protected from abortion during the second and third trimester. That creates protection for unborn children after the first trimester, or approximately 13 weeks. That is very closely consistent with existing Nebraska law that creates that same protection at the 12-week.
What about, thank you. In the case, sometimes this is referred to as protect women and children, but you're telling us actually it's protect children.
I believe that the primary purpose is to protect unborn children, but I do believe there is a secondary purpose of protecting women, correct?
So this would give constitutional rights to a fetus.
Your Honor, it would give one specific constitutional right to an unborn child, specifically the right to be protected from abortion during the second and third trimester. But it would give
how and who would enforce those rights?
Your Honor, the right would be enforced by individuals who are enforcing the existing and other abortion and criminal laws regarding that issue. So I think that's who would protect those rights.
Are they unborn children persons for the remainder of the Constitution?
They are not, Your Honor. The argument that I heard this morning about opening Pandora's box, that argument pretends as if this initiative read that all uses of persons in the Nebraska Constitution shall now include unborn children, but that's not remotely what this provision says. So I don't think that Pandora's box concern actually exists. As I was saying, I think the primary purpose is to create constitutional protection for unborn children from abortion consistent with existing Nebraska law. And I talked a little bit about that second clause. I think the first clause is also directly related to that because it addresses instances of medical emergency, sexual assault, and incest. And all of those situations are already addressed under existing Nebraska law, so it fits squarely within that primary purpose. There are other ways that the court could characterize the primary purpose, and I think no matter how the court characterizes it, we easily satisfy. I'll give the court just one other example. If the court were to raise the level of generality on the primary purpose that I've initially offered and say that the primary purpose is to create constitutional protection for unborn children from abortion after the first trimester period, then that essentially encompasses what that second clause, the independent clause, does. So all we have to do is show that the first clause dealing with medical emergencies, sexual assault, and incest is naturally and necessarily connected to that. And we can easily make that showing. As to a natural connection, an unborn child is physically connected to the pregnant woman. And so it makes natural sense to place some limitations on that unborn child's interests in the context of the pregnant woman experiencing some kind of tragedy like medical emergency, sexual assault, and incest. And as to the necessary
Do
connection.
we know where the language for this initiative came from? Is there some precedent that we can look at for legal precedent?
Your Honor, it was pulled directly from existing Nebraska statutes, specifically the Preborn Child Protection Act that this court recently considered in the Planned Parenthood case. That's where the language specifically dealing with medical emergencies, sexual assault, and incest comes from. And so, as we've argued in our brief, the old soil surrounding that terminology comes over into the constitutionality with it. Into the Constitution with it. One point I'd like to make is I believe that the relator's case is based on an entirely false premise. Their premise is that if you were to direct the secretary to withhold the abortion initiative based on any of the arguments raised in the Brooks or LaGreca matter, then you necessarily have to direct the secretary to withdraw the other initiative. And I just do not think that is right. There are many arguments that are made in that case that have no application in this case. Let me give you one example to illustrate it. As we heard earlier this morning, one of the arguments is that the abortion initiative creates competing, different kinds of competing abortion rights, some in the women and some in third parties. If you were to accept that argument and say that those are two different subjects that the voters should have the right to consider separately, that has no impact on the children initiative that's at issue here. Why? Because only one class of individuals is given one category of rights. That is unborn children protected from abortion. Straightforward. There's nothing else here.
I'm
So
kind
I
of
don't.
back to the other part of this. So in your view, then, the unborn children get rights, and finish the sentence, do women get rights under your proposal?
We believe, well, our proposal is that the other purpose is to protect women, and we do believe that this protects women. So is that, I'm sorry, was that your question, Your Honor, or am I not following it?
I don't think that's quite corresponding to what I'm trying to tease out
Sure.
here. You said protecting the unborn children. Does this proposal protect pregnant women?
This proposal creates limitations on the protection for unborn children to address situations where tragedies befall pregnant women. So yes, in the context of medical emergencies, sexual assault, and incest, there is a limitation imposed on the right created for unborn children.
Thank you.
There's another example where if the court were to accept an argument in the Brooks or LaGreca matter, it would not import into this case. And that is, you heard the argument this morning that one of the problems with the abortion initiative is that it transforms medical practice and medical standards. And that argument is based on the redefinition of the concept of viability and the expansion of the individuals that can make that viability determination. Again, there's nothing remotely like that at issue in the Children's Initiative. It does not adjust in any way medical standards or medical practice in the state of Nebraska if the people were to approve the children.
So to summarize, to see if I'm following you, so the lawsuits don't follow each other necessarily. They don't rise and fall together in your view?
They do not, Your Honor. The fate of one of the initiatives does not rise and fall with the others. They have to be addressed on their own to the extent the court thinks there's jurisdiction.
So getting back to the single subject in this one, right? There's challenges to single subject, right?
Arguably, I think on paragraph 30 of their petition, they've conceded that this initiative here complies with single subject requirements. But if the court disagrees with that and thinks there actually is a case or controversy, they do raise some arguments at some point in their brief. And I just think that those
But
arguments
they're
are
saying, well,
misplaced.
this one, it could, in some person's view, be about children and women.
Your Honor, I don't understand them to be making that argument. The point that you're making this morning, I don't understand that to be their argument. Their primary argument seems to be that by including the phrase unborn children in the Constitution, that we don't know what ramifications that might have. And my response to that is twofold. First, we know exactly what the ramifications might be because the text says it. It says unborn children shall be protected from abortion during the second and third trimester, no more, no less. So this idea of Pandora's box opening is simply misplaced. And secondly, all the court needs to do is run a search through Westlaw, through all of Nebraska statutes, and you will see the term unborn child and unborn children all over the place. The legislature uses it all the time. So this is not something foreign to Nebraska law, and I would encourage the court to not accept this argument about Pandora's box.
Before you sit down, Mr. Campbell, I want to ask you too, can this court change the concept of ripeness that we've been working with over the years?
Your Honor, I thought you might ask me that. So I gave it some thought while I was sitting there. My sense is, of course, ripeness is judge-made doctrine, so you would have to overturn existing precedent. I do think that you would need to do that. Having said that, perhaps a more sensible line that the court could draw, and it's not without concerns, but I realize that this time crunch is not what this court ideally should be operating under. So one idea is you can't go too far back in the process because otherwise then the case just feels really unripe. But perhaps when the signatures are submitted, if more than enough signatures are submitted, perhaps the court could try to move the ripeness line back there so that it would have multiple months to consider this. Now, having said that, there still is a ripeness question.
So that would have taken it back to July.
It would have taken it back to July. So I'm trying to give you a little more time, Your Honor. I'm maybe not
talking maybe a couple of months.
Alternatively, perhaps the court would like to include a paragraph in its opinion where it makes a suggestion to the legislature to create some kind of mechanism where this kind of a challenge can be brought earlier in the process.
There are states where this happens, right? I mean, the Florida case that was referred to earlier today was decided in April and via an advisory opinion. Would legislation be required to have something like that here?
Your Honor,
constitutional amendment.
I believe it would. I believe there would be some sort of legislation that would be required to mimic the Florida process, but that might be a better way to do it because I do think that these are important questions, important issues, and to put the court in such a time crunch is not ideal.
Could we go all the way back without the legislature? Could we go all the way back to when the petition is initiated and the Secretary of State does something and says, okay, now you can go to the farmers markets and start collecting signatures? Could we go back that far and say it's ripe at that point in time?
Your Honor, I suppose maybe you could, but I think that would be straining ripeness because as the court well knows, many of these petitions that are approved for circulation, they never gather even close to the requisite number of signatures. And so I think that might be going a little too far back in the process, but perhaps, and that I believe the Florida process that has been created by statute there, it does go back further in the process. I'm not sure if quite that far back, but certainly back further than the line that I'm suggesting.
Well, as luck would have it this season, not all initiatives are being challenged in court.
So far.
True,
So far.
but
We'll look at
it seems like a lot of
the
them
queue
are.
when we get off the bench.
That's correct. Thank you, Your Honors.
Thank you very much.
Thank you.
Do we have time for rebuttal?
We do 1 minute, 18 seconds.
1 minute and 18 seconds, Mr. Gashak.
Thank you, Mr. Chief Justice, and I'll try to use far less than that. On the ripeness front, I would urge the court to remember that it is in large part a prudential doctrine, and the hardship to the parties is one of two key elements of that test. Seems to be a very natural setting for the court to, as the questions have suggested, potentially make different law to make hardship on both the parties and the court lessened in this context. But here, denying the Constance challenge on the basis of ripeness would work an immense hardship on the parties who represent the voters, because what my friend is arguing effectively amounts to, for a procedural reason, one amendment initiative should be judged by a different standard than another, or potentially could be. And that can't be what Nebraska constitutional law requires. Thank you for hearing us. Thank you for your time.
Thank you very much.
Thank you.
Council, that concludes arguments in State Ex Rel Constance et al. Versus Evnan. And that concludes arguments for the day, hence you are excused.
Nice to meet you.